Welcome back, future criminologists. In this video, I will be discussing inquest proceeding. Before we begin, I would like to inform you that this topic is related or a continuation of the discussion on preliminary investigation. Preliminary investigation was already discussed in our previous video. I will put the link on the description box. When is preliminary investigation not required even if the offense is one which normally requires a preliminary investigation? If a person arrested lawfully without a warrant involving an offense which requires a preliminary investigation, an information or complaint may be filed against him without need of preliminary investigation. If he has been arrested in a place where an inquest prosecutor is available, an inquest will be conducted instead of preliminary investigation. Dito po papasok ang inquest proceedings. In the absence of the inquest prosecutor, the complaint may be filed directly with the proper court on the basis of the affidavit of the offended party or the arresting officer. And now, let us discuss inquest proceeding in detail. Inquest proceedings. Inquest proceeding is conducted when a person is lawfully arrested without a warrant, even involving an offense which requires a preliminary investigation. When is a person considered lawfully arrested without a warrant? There are three instances when a person considered lawfully arrested even without a warrant. To wit, 1. When he is arrested in flagrante delicto. 2. When there is hot pursuit arrest. 3. When the person is an escapee. I will discuss arrest in flagrante delicto and hot pursuit arrest in a separate video, so subscribe to be notified in our upcoming uploads. The third kind of warrantless arrest is self-explanatory. Necessarily, an escapee must be brought back to the prison or in the place where he is serving sentence without any warrant of arrest to be issued again by the court. Nature of the right to inquest proceedings. Inquest proceeding is not preliminary investigation. Rather, it is an informal and summary investigation. Purpose of inquest proceeding. The purpose of inquest proceeding is to determine whether or not the person detained should remain under custody and then be charged in court if there is probable cause. Who has duty to conduct inquest proceeding? Inquest proceeding is the duty of public prosecutor, who is assigned inquest duties. Commencement of inquest proceeding. Inquest proceedings commence from the time the inquest officer receives the complaint and referral documents from the law enforcement authorities. What are these referral documents? The following are the referral documents. 1. Affidavit of arrest. 2. Investigation report. 3. Statement of the complainant and the witnesses. 4. Other supporting documents gathered. Note that the detained person should be present during the inquest proceeding. If necessary, the inquest prosecutor may require the presence of the complaining witnesses and subject them to informal and summary investigation or examination for purpose of determining the existence of probable cause. Instances when production of detained person before the inquest officer is not necessary. 1. If the detained person is confined in a hospital. 2. If the detained person is detained in a place under maximum security. 3. If production of the detained person will involve security risk. 4. If the presence of the detained person is not feasible by reason of age, health, sex, and other similar factors. So, when there is inquest, what are then the possible actions or duties of the inquest officer? The initial duty of the inquest officer is to determine if the detained person has been arrested lawfully. The inquest officer may summarily examine the arresting officers on the circumstances surrounding the arrest or apprehension of the detained person. If the arrest is not lawful, the inquest officer shall recommend the release of the detainee. When the recommendation is approved, the order of release shall be served on the officer having custody of said detainee. If there is valid warrantless arrest and there is probable cause, the next action is filing of case with the court. Note that the inquest must pertain to the offense for which the arrest was made. For example, Juan was caught in flagrante delicto in killing his victim Jose. Upon verification, Juan has also an outstanding warrant of arrest for the crime of theft he committed months ago. Here, the inquest proceedings must pertain to the crime of homicide or murder as the case may be, and not the crime of theft. What if the person arrested lawfully without a warrant wants to have the conduct of preliminary investigation instead of inquest proceeding? Such person arrested lawfully without a warrant may, nevertheless, ask for a preliminary investigation before the complaint or information is filed, but must sign a waiver of the provision of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Article 125 imposes a penalty upon a public officer or an employee who, although having detained a person for some legal ground, fails to deliver the person arrested to the proper judicial authorities within the periods of 12, 18, or 36 hours as the case may be. What if the person arrested lawfully without a warrant have no knowledge that a complaint or information had already been filed with the court? Can he still request for a preliminary investigation? Yes. If an information or complaint has already been filed, the person arrested, who is now considered as an accused, may still ask for preliminary investigation within 5 days from the time he learns of its filing. To end, please subscribe to our channel and stay tuned for more videos.